Hi Jonathan, I hope you are doing good today. So today I along with my group members gonna present business and corporate law presentation, and we have two main parts in this presentation. One is based on the contract law, other one based on the corporations law. And to ease out the things, we have divided each part into five basic things. The first, we're gonna present the facts of the case, what the case actually is. Then in the second part, we're gonna discuss the issue, the main issue, to pinpoint the main issue that on which we're gonna apply the rules in the third part. Rules will be relevant to the issue, and then we're gonna put in the application of those rules, that how we're gonna decode the scenario, and at the end of the part, as usual, that would be the end of the story by providing the conclusion. So let's start off with the part A. And for the part A, the case is that there's an owner by the name of Ming, and he runs a hair salon. And his hair salon name is Hairlines. And to promote his business, he actually advertised in the local newspaper that whoever produced the advertisement on his hair salon will get a $10 haircut. So after the publication of the advertisement, he soon realizes there were like 50 people arrived at outside the hair salon to get the $10 haircut, of course. So soon enough, he realizes that if this thing continue to grow, he gonna face a lot of loss in his business. Of course, with the $10 haircut, he gonna face a lot of loss. So he decided to put a sign that says that the offer of haircuts that was placed has now been finished, totally closed. That's it. So the main issue here is, in this case, is whether an advertisement as given by Ming is an offer or an invitation to trade. So a very basic thing to remember, what's the difference between an offer and invitation to trade? So that would be discussed by my next partner by applying the rules and then the application. So I will hand over my presentation to Deepa now.
Thank you, Usman. I'm going to present the rest of our presentation of Part A. In this study, we have included some rule based on the previous case. Rules. The first case is the case of parties versus criterion, which state that a person cannot sell more than what he or she has, and an advertisement should be treated as an invitation to treat rather than an offer. And in the case of Carlyle versus Carbolic Smoke Bulko, if the public is asked to act in a specific manner, an advertisement can be treated as an offer to the public at large. The third case is the case of Chappell, Co. and Nestle, which state that inadequacy of consideration is irrelevant while deciding whether a promise is enforceable or not, and it is necessary that consideration of some value exists. Now next is application. Here we have three scenarios. In the first scenario, 40 customer produce the advertisement before the notice goes up in the window. Here the main question is whether this customer would be in a position to enforce the legal agreement. The answer depends on whether the advertisement was an offer and whether the same was validly accepted by them or not. The answer depends on whether the advertisement was an offer and whether the same was validly accepted by them or not. If this case is treated as an acceptance, he needs to serve an unlimited number of customers, which is not feasible. So advertisement need to be treated as an invitation to trade, and customers shall not be in a position to enforce any agreement against hairlines. In second scenario, 10 customers do not have the advertisement with them but want to participate in the promotion. These 10 customers fail to meet the condition. Seller has right to refuse the sale of the item, so the customer would not be able to enforce any agreement against hairline. And in the third scenario, whether Ming would argue the payment of $10 is insufficient, and what about his legal obligation on the business. The court does not look at the sufficiency of the consideration. So if there is no consideration at all, the contract might not be legally enforceable. If the advertisement is taken as an offer, he would not be able to claim that $10 is not sufficient. Finally, in conclusion of part A, the advertisement was an invitation to trade, and Ming is not obliged to accept all the offer he received following the advertisement.
Thanks, Deepa. Now, as my mates told that the second part B is based on the corporation law, now I'm going to describe the scenario as the facts of the case. A person wants to start a company which brews coffee on the stoves at home without using the expensive coffee machines. And he wants to start at a low cost or as a low cost way to brew coffee. And the next thing is that he wants to start the company with the name as Anjak Coffee. And by the end of the one financial year, the company is estimated to have the assets of 5 million as well as the employee of 20 people and the gross revenue of about $10 million. And by the end of 5 years, the company will have the assets as 13 million with the expected revenue of 26 million. And if the company goes through the same way of success, then the company will have 5 people on the full-time basis as well as 66 people at half-time of a full-time equivalent. Now, according to the facts of the case, there are three issues, and they are if he wants to start a company, under what type of company he should register, and according to this and going through the second issue, if he wants to name as his company as an Anzac Coffee, he should confirm that if anyone had previously named under the same name or not. And the third issue is that will the company fall on the category under the same category after 5 years of time or not? These are the three issues, which is based on three.
Thank you, Sonu. Now I'm going to discuss the rest three parts of the given scenario: the rules, application, and the conclusion. The first part is rules. There are certain rules that need to be followed by every company while operating it. The first one is that every company need to be registered. And the second one is the person who need to register a company should look for the available name that should characterize its nature, object, and the functions of the community. Furthermore, it shouldn't be undesirable for any section of the community. There are some distinction between the small property group and the large property group. The first one is the gross revenue of the company should not be less than 25 million. The value of assets should be less than 12.5 million, and the number of employees should be less than 50 million for the small company. If any of the company breaches out of these two thresholds, it shall be treated as a large company. Regarding the application based on the rules, the first one is in the beginning, every company can be registered as a small property group. But as in the above scenario, at the end of the fifth financial year, its revenue exceeds 25 million and the value of assets also exceeds the 12.5 million. In this case, the company should be reclassified as a large company. Furthermore, according to the name, the company owner named it as Anzac Coffee. The word Anzac means the fallen soldier, so it misleads the customers and does not characterize the nature, object, and the function of the company. Therefore, every company in the beginning can register as a small property group, but with the time, according to its revenue and assets, it should be registered as a large company. And in regards to the name, the Anzac is not appropriate for the given company.
Alright, so at the end of the presentation, I would like to thank my group. They have put all the scenarios real well. And just at the ending note, as we have seen, this subject is crucial in terms of how we see the scenarios from the common sense point of view and how we see it from the business and the law actual point of view, right? So as in the part A, there was a very fine and a thin line between an offer and the invitation to offer. So they are like the totally different thing. But in common sense hearing, it's like one person can say it's like almost a similar thing, but it's not. That's why we study law, and that's why we have a wonderful teacher like Jonathan, right? All right, so at the end of the part B, we can say we can't really use the Anzac Day name just because it's not relatable to the coffee, right? And that's what we all wanted to say in our presentation. And we thank you, Jonathan, for all the guidance you have given to follow up on the presentation. Thank you very much.